In recent months, immigration policy and enforcement in the United States have entered a new phase, marked by dramatic initiatives, legal confrontations, and heated debates about the nation's future. At the forefront of this evolution is Florida's newly constructed detention center, dubbed Alligator Alcatraz, a name that evokes both its remote location and its intended role as a formidable barrier against illegal immigration. Situated on a sprawling 30-mile property deep within the marshy Everglades, the facility was rapidly converted from a former training base, equipped with its own airstrip to expedite the deportation process. Since its official opening in early July 2025, Alligator Alcatraz has already seen the departure of approximately 100 detainees, flown to undisclosed destinations abroad. Hundreds more have been transferred to other detention hubs across the United States, prepping them for eventual deportation. With a current capacity to hold up to 2,000 individuals and plans to double that number, the facility represents a significant financial and logistical investment, estimated at $450 million annually, with Florida expecting reimbursement from FEMA. Despite fierce criticism from a group of Democratic state lawmakers who raised concerns over allegedly inhumane conditions after a recent tour, Governor Ron DeSantis remains unapologetic. He dismissed their outrage as political maneuvering, pointing instead to the suffering of families, often referred to as angel moms, who have lost loved ones to crimes committed by undocumented immigrants. DeSantis and his allies argue that the creation of Alligator Alcatraz is a necessary and compassionate response to a broken system, and the Trump administration is reportedly encouraging other states to consider similar facilities. Simultaneously, the federal government has reignited its legal battle against so-called sanctuary cities, jurisdictions that limit local cooperation with federal immigration enforcement. The Department of Justice's most recent lawsuit targets New York City, alleging that its sanctuary policies directly obstruct federal immigration law and enable dangerous criminals to remain on the streets. This legal action was spurred in part by a high-profile incident in which an off-duty Customs and Border Protection officer was shot. The suspects, both undocumented migrants with multiple prior arrests, had repeatedly evaded federal custody due to the city's refusal to honor ICE detainers. Former acting deputy chief of staff at DHS, Laura Reese, has strongly backed the lawsuit, calling the crime preventable and urging the administration to pursue similar actions against other sanctuary jurisdictions. She points to what she describes as a dangerous combination of open borders, local sanctuary policies, and rogue prosecutors and judges that she believes facilitate a revolving door for repeat offenders. The legal justification for these lawsuits rests upon the Supremacy Clause of the U.S. Constitution, which gives federal law precedence over conflicting state and local statutes. While local leaders often argue that immigration enforcement is a federal responsibility, federal officials contend that local obstruction undermines the rule of law and public safety. This tension between federal authority and local autonomy is now playing out in courtrooms across the country, with the outcome likely to shape the landscape of immigration enforcement for years to come. In another legal front, New York and 20 other Democratic-led states have filed suit to restore taxpayer-funded benefits for undocumented immigrants. These benefits range from welfare and Medicaid to public education and housing. Critics argue that such policies impose a heavy burden on taxpayers, pointing to California's $6 billion cost overrun for providing free health insurance to undocumented residents, and claim that public resources should be reserved for citizens and legal residents. Proponents, however, maintain that access to essential services is a matter of human dignity and public health. Finally, the question of birthright citizenship has returned to the national spotlight. The Trump administration's executive order, which would deny citizenship to children born in the U.S., unless at least one parent is a lawful resident or citizen, has now been blocked by a second federal court. Supporters of the order argue that the 14th Amendment was never intended to grant automatic citizenship to the children of undocumented immigrants, and describe birth tourism as an exploitation of constitutional loopholes. Opponents counter that the proposed restrictions are legally dubious and at odds with long-standing American tradition. Together, these developments reflect a nation grappling with complex questions of law, identity, and belonging, debates that will continue to define the American experience in the years ahead.